Okay, well, welcome IFA friends. My name is Mike Lehman from IFA Government Relations, and thank you for joining us. We are very happy to bring you today's special IFA member briefing, what franchisees need to know about joint employer. And this is really a program for all corners of the franchising community, because we are gathered today because on October 26th, a Washington, D.C. agency known as the National Labor Relations Board issued a new law determining what it means to be a joint employer. And if you're not sure what a joint employer is to begin with, or how it applies to franchising, this program is for you. So we're very glad you would join us. And this is the second time in a decade that the NLRB has imposed such a joint employer standard that may deeply impact franchising. So we're going to be able to revisit some of the lessons learned from the previous time the NLRB has manufactured this policy on franchising from 2015 to 2017, and we will look ahead for what to expect on this policy. On today's program, you will hear from an expert lawyer, franchisee, and franchisor on what this joint employer issue means for franchise business people, and you will learn some unique ways that you can make a difference with lawmakers who will decide the fate of this issue. Two announcements before we introduce our three great friends and speakers today. First, today's webinar is being recorded, so you can share this with colleagues and franchisees by going to our community.franchise.org site later today. That site again is community.franchise.org. We will also be sharing this recording through a number of upcoming IFA communications. Second, we will take questions from you, the audience, later in this program, and you can enter your questions on joint employer at any time during the program through the question and answer box on your Zoom screen, and we will pose as many of the questions to our experts as we can. With that, allow me to introduce our speakers, each of whom is a franchising expert and IFA leader. First, we have Jerry Akers. Jerry is a multi-unit franchisee of both Great Clips and the Joint Chiropractic, and he is based in Iowa. Jerry testified before Congress earlier this year on workforce issues, and he is the chair of the Franchisee Forum. Sam Ballas is president and CEO of East Coast Wings and Grill, based in North Carolina. Sam is the chair of the Franchisor Forum. But first, today we will hear from Amy Chang. Amy is partner at Chang Cohen, based in Chicago. Amy is an expert in general corporate, franchise, licensing, and distribution law, and we are very pleased to start our program with Amy. And we're going to ask Amy, and she will explain what happened and what did the NLRB do here, and why should franchise business people care. So with that, Amy Chang, welcome, and the show is yours.
Thank you, Mike. So let me step back before I get into the NLRB and the new rule. Mike has said, joint employer, what is it? I'll do a 10-second, explanation for those of you who are new to the joint employer issue, which I know most of you are not at this point. Unfortunately, we've all heard the word about a billion times and probably very tired of it. But joint employer liability really is when you have two companies who are deemed to both be employers of an individual. Okay, so when it comes in terms of the franchisor-franchisee context, I think what we're talking about is when would a individual who's working for the franchisee also be deemed to be an employee of the franchisor, where franchisor and franchisees are joint employers of an individual. Okay, so that's I think in franchising what we're all talking about and what we're concerned about. We want to make sure that franchisees have retained the independence as an employer of their employees, right? So when I looked at, in preparation for this, I looked at the first rule, that Mike talked about, which is for the first time in February 2020, the NLRB addressed this joint employer doctrine through rulemaking. Okay, so I was surprised, when I read some of these materials in preparation for this. Wow, it really was just 3 years ago that this happened. And that was the very first time the NLRB issued a rule to doctrinate joint employer liability. So in 2020, the board promulgated a final rule that when it came out, the community was very happy with, because it actually narrowed the joint employer standard. Okay. In 2020, the rule provided that there's joint employer if two employers share or co-determine the essential terms of and conditions of employment. Okay, the key to that is essential terms and condition. Okay, so that is the 2020 rule. In September of 2022, the NLRB proposed a new rule, and between 2020 and 2022, the composition of the board changed, as many of you know, which is, I think, one of the reasons for the proposed new rule. And so the proposed new rule broadened kind of the standard of what could be deemed joint employer. And in October 2026 of 2023, on October 26, the final new rule came out. So when I went back and looked at the proposed rule and the final rule that actually came out, the NLRB actually broadened the standard even more between the proposed rule to the final rule, believe it or not. So in the next slide, I kind of want to walk through, next slide, okay, want to walk through what has remained the same between the old rule and the new rule, okay? Conceptually, it is similar in that the question is, did the alleged employer share or co-determine, i.e. have control over the employee's terms and conditions of employment? Okay, that sounds narrow enough, right? As franchisors, we don't want any control over the essential terms of the employee's terms and conditions of employment, right? So the difference, what has changed between 2020 and 2023 is if those are the same. The question is, what is control? Under the old rule, if you look at the old rule, next slide, define control to mean possess and exercise substantial, direct, and immediate control over one or more essential terms and conditions of employment. Okay, so the key is, in order to be deemed a joint employer, you have to possess and you have to actually exercise that control, right? Let's go to the new rule now. The new rule provides that you either possess and you exercise the control, or you simply retain the authority, okay, to exercise the control. And that's huge. If you think about it from a franchisor's perspective, think about your franchise agreement, right? And what kind of authority do you retain that you may or may not exercise? So it will make us rethink what kind of authority we want to retain. And if we're not going to exercise it, should we retain that authority? Okay. I'll go to the next slide, which is even more of a difference. The terms and conditions under the old rule, it was very specific and the definition was narrow. Okay. There were 4 things that went into that analysis: wage, benefits, hours of work, and then hiring, discharge, discipline, supervision, and direction. Okay, so if you think about it, you look at it, put on your franchisor hat, look at this definition of terms and conditions of employment, you think, okay, when I advise my client, it seems pretty easy. Don't talk about wages, don't dictate the benefits, let the franchisees do that. Let the franchisees dictate when their employees should work, should not work, right? And with respect to hiring and firing, let the franchisees make that decision. Okay, so it was much easier to be able to advise the franchisors what are the lines that you should not cross. Okay, now let's fast forward, next slide, to the new rule. Look at that. This is the new broad definition of what should be considered when determining whether the joint employer controls terms and conditions of employment. Okay, we have all the old ones. Okay, and then in addition, we have included, for example, if you look at the slide, scheduling. We have work rules and direction governing the manner and means and methods of the performance of duties and grounds for discipline. Okay, supervision of the performance. And then the one thing that was added actually between 2022, when the proposed rule came out, and the final rule that was issued in 2023 was that very last bullet point, which to me is so broad, and that's a bullet point that we really have to think about and analyze, which is you would be deemed a joint employer if you somehow retained the authority to control working conditions related to the safety and health of employees. Okay, if you think about that, that's pretty broad. Working conditions related to the safety and the health of the employees. As a franchisor, for many of the concepts, think about the system standards that we issue that protect the brand, right? That are facing the consumer. You now have to think about what of any of those standards could possibly be interpreted to impact the working conditions of the franchisee's employees. Okay, so that is, I think, the biggest change from the old to the new rule. And now, what does this mean? A lot of my clients say, okay, that's all great, but how is this going to impact me? And with respect to in the short term, the NORB ruling, may not be a huge immediate impact, I think, to franchisors, because it really relates to whether the franchisor and the franchisee may have to work together to negotiate with labor unions, right? It has to fall within the jurisdiction of the NORB for this new rule to make an immediate impact. However, as we have all seen, what happens when there is a new board rule of any kind of governmental authority, right? What does this mean in terms of how is this final rule going to impact other agencies? How is it going to impact how the court interprets joint employer liability in the other jurisdictions? Okay, so I think that's one of our main concerns, and I know that the IFA is working very hard. I'll let Mike speak more to that on kind of why are we afraid of that, and what are we doing in order to make sure that there is hopefully no long-term impact on the franchising industry. And with that, Mike, I'll give you back the mic.
Great, Amy. Thank you so much for that. You see Amy's descriptions of how the standard and the factors that will be considered for franchise business people are going to deeply expand on December 26th when this policy becomes law. And so, Amy, thank you. We're going to bring you back into more of the conversation in a moment. But before we welcome in Sam Ballas and Jerry Akers and get their take, I do want to share with you more about the why should we care point that Amy was making, and give you a picture of the economic data on franchising that was measured the last time the joint employer standard was changed from 2015 to 2017, as you see on your screen. Economist Ron Bird worked with us a handful of years ago in our comments for the 2020 rule that Amy mentioned. And we found that from all sorts of research with franchisors, franchisees, the 2015 standard over that 3-year period cost the franchising community over $30 billion each year in increased operational costs, increased legal costs to navigate this new policy. It resulted in over 300,000 franchise job opportunities lost, and it nearly doubled litigation against franchises in that time frame. So some of those who cherry pick on the franchising community capitalized on the previous standard, and we saw that measured in the lawsuit metrics. So on the next slide, so that's what happened before. Now, what do franchisees expect now? In anticipation of this rule, we asked Oxford Economics to survey franchise owners on their perspective of what this rule will mean. And in the survey that Oxford Economics released in September, 2 months ago, of 1,300 franchise owners, found the following things. 87% of franchisees said they would be concerned if the NLRB rule compels their franchisor to take more control over their operations. Okay, so that's an overwhelming statistic. And correspondingly, 82% of franchisees said they would be concerned if the NLRB rule compelled their franchisor essentially to take less control and have a more distanced relationship of their operations and compliance support. I mean, how many franchisees were awfully grateful to be in a franchise system in those early days of the pandemic as we all navigated compliance and PPP access and all the things that were important. So whether the NLRB rule is likely to do one of two things in most franchise systems, it may encourage franchisors to take more control or less control. And franchisees overwhelmingly think both of those are negative outcomes. And perhaps most compelling of all, as in our advocacy, is that only 14% of franchisees said they would have definitely opened a franchise business if this NLRB policy was the law of the land. Pretty compelling stuff. So now we will welcome in Sam Ballas and Jerry Akers, our good friends and franchising experts. And so I'm going to turn to Jerry first in light of everything you've heard here. Jerry, you've heard Amy explain the policy. You've seen the survey research on what franchisees' view of the new policy. Tell us your view of the joint employer issue at this stage, and then we'll go get Sam's take.
Yeah, sure, Mike. Thanks a lot. I appreciate the chance to speak out on this. As you said, we've been fighting this for many, many years, and it just keeps coming back. It's like whack-a-mole in DC. The bottom line is we lose control over our staff. We have a situation, so one size fits all. So things that are relative in, LA or Chicago are way different than they are in the more rural areas that many of us serve. So the fact is, we're going to lose control. Literally, I don't know what this 14% of franchisees that say they'd still do it, I don't know where they're coming from, because the hurdles we're going to have losing control over our staff and not being able to amend what we're doing and how we do business to some extent because of the municipality we're in and those kinds of things, it's going to just add another level of concern and issues and work and stress to us as franchisees. And frankly, most of us bought these expecting to have some interaction with corporate, but more at an on and off again type situation. If they're responsible for our franchisees in conjunction with us, it's going to be a day in and day out, a regular type occurrence where we're having interaction with them. I see this as increasing costs, increasing stress, and frankly, driving people out of franchising, Mike.
Jerry, and it's already a labor shortage. IFA research also shows that the biggest problem for all of you in the business is finding workers and the cost of those workers. And this is going to put yet another barrier in between your relationship with your employees. Thank you, Jerry. Sam Ballas, we welcome you in. What's your take?
Good to be here. And of course, I'll echo everything Jerry just said, but I'm gonna take a minute or two and kind of go back in history a little bit, right? This fight started, 12 years ago? So 12 years ago, franchisors were put in a position on the first round of this battle. How do we distance ourselves from these definitions that they are working on, or what the Obama administration wanted to do back in that administration? And I can tell you that being in a lot of forum meetings and a lot of C-suite meetings, a lot of franchisors were spending a lot of money and energy trying to figure out from a legal perspective how to distance themselves from being caught up in the current then definition before the Trump administration created the different definition. And now, as Jerry said, the whack-a-mole mentality, we got yet another definition that's got two different elevations to it, right? We got one definition, months ago, and we're told, we're not going to be that tough on franchising. And then this thing came out in October that was extremely broad, right? So 12 years ago, franchisors were working on scenarios of, in our company, changing the language, as Jerry just mentioned, working with corporate, right? We don't do that in our brand. You work with a national franchise service center, right? We quit working with general managers at location on the front lines. We started working with our franchise owners, assigned agents. So it started 12 years ago. How do you put your FDDs together, your franchise agreements together, to try to give you the opportunity just to navigate? In our system, we had emails not just for our franchisees under our brand email threads, so we can send proprietary processing to the franchisees. We were allowing at corporate expense or the service center's expense, we were allowing their assigned agents to have emails, or the general managers prior all this NLRB issues arose. We took those away. We then assigned location emails, and we gave that liability to the franchisee and the franchise owners on how they're going to manage when they went through a change of management. Would they remember to change those passwords so the old management levels wouldn't see the proprietary information going to the stores that had to go to the stores? So this is a huge concern for the franchisors and franchisees. I think that what really is concerning is this broadness of authoritative control. I mean, you go into franchising as a franchisee, and you're going to a franchisor that you have picked in all associations of, they had a model of a product or service that they had innovated, and they built a company around it, and they took it to franchising. And when they go to franchising with it, then basically we have gone through all the hurdles as a model, trying to weed out all the bumps and bruises a new business will go through with some type of an earnings opportunity. And in our brand, and I'm a big advocate of item 19 for earnings claims. So all of a sudden now you get the NLRB coming in saying, hey, all those things you've done for all those years, 70 plus years of franchising, we're going to basically whittle it down to a broad definition that will attract any type of argument. I'm in the restaurant space. I mean, how do you manage helping the profit and loss statements of a franchisee if you are a unit level economics driven philosophy, when you have to educate them on doing prep work at the restaurant level? You have to educate them cleaning procedures at the restaurant level as best practices, those things that keep employees safe across the board based on how we have our development and our kitchens designed. All those elements now come into question. Can we do the modeling for the right type of payroll expense? Can we do the modeling for the right type of timing it takes to prep that helps a franchisee and their authorized agent drive a middle of the P&L, a GA of the P&L more profitable? So this goes way beyond just, what they're looking for and helping the unions get into the space of unionizing a lot of franchising. This really encumbers a franchisor and supporting the franchisee the way that the franchisee should be supported.
Very insightful history, Sam. Thank you for that. Jerry, what do you recall from the previous joint employer saga from 2015 to 2017, and what's instructive moving forward, do you think?
Yeah, thanks, Mike. One thing maybe I should position here first, for those of us that don't know us, for those of you who don't know us, those on this call swim in the franchise pool day in and day out and have for decades. And so we don't just base our comments on what our franchise systems are doing, but what the global franchise systems are looking at. So when I look back in the rearview mirror at what went on back then, what was most concerning was I saw subtle insulation and moving away between franchisors and franchisees. So franchisors were looking for ways to protect all of us, both sides of that equation, from a potential joint employer decision. So many franchisees would complain that certain things weren't the same. Some of their support had changed, especially employee-facing type things. And that was entirely driven by this protection mode that franchisors went into, again, to protect us as franchisees from being drawn into a joint employer situation. You know, you'll hear from time to time that franchisors are doing it just for their own good. But the fact is, I, as a franchisee, don't want anybody else managing my staff. I want to make sure I manage them the way that I want to manage them, give them the benefits and so on that I want to do that. So when I look in the rearview mirror and I see that distancing and insulation that went on, I can only imagine it's going to be way worse if this continues to move forward. Literally, I consider this as a situation where we literally move to the point where we're not doing hardly anything as far as managing our staff. It's edicts coming down from a corporate entity pushing us to do things a certain way. Sam touched on it, I think, greatly when he talked about, you know, in the restaurant space that franchisors would have to deal more with safety and cleaning and all those kinds of things rather than things that grow and build your franchise system and the business that you just bought into. So as a franchisee, that insulation and distancing, I think it's going to change the relationship between franchisee and franchisor to the point where right now it's more of a team, I think, between most franchisees and most franchisors. We sink and swim together. We work together towards a common goal. I think it's going to somewhat alienate the two sides if it moves forward, because we're going to have to look at things completely differently as far as how do we operate our businesses. And it is not going to be what we've been used to in the past. So that's what I see in the past and how I see that moving into the future, Mike.
And let me jump in and clarify something. You know, when I say a minute ago that, franchisee labor models, a franchisor has a model of a revenue source that the brand produces as an AUV, an average unit volume revenue source. And if you're going to do earnings claims as a franchisor, you have to have some type of a model as a benchmark for franchisees to benchmark against, right? And that data comes from the franchisee deliverable of the profit loss statements. So when I say build a model, I'm not saying we go into franchise units and look at their schedules to build their model, but you have to retract that data. Well, if retracting that data with this broad authorization of control that the NLRB now has really broadened, is it going to make it be a bad thing to retract data? We have to have the data. How can you take a model and change with the times and new normalities and what we've all dealt with in franchising on post-pandemic to assure the franchisee and deliverable in their goals is there driving the unit level economics? Are we going to be handcuffed now getting data from the franchisee that we need to keep those models in check, to make sure that your menu pricing is right? It's hugely encumbering when you're getting involved in a franchising system that has a clear licensing track record, a congressional track record for that matter, of how do we protect our intellectual property and how do we support that piece of the franchising which the franchisees are licensed to perform.
Sounds like a fundamental and unfortunately artificial change to the franchisor-franchisee relationship. So,
yeah, let me jump, Mike, one more quick thing, and then Jerry can chime on this, because you mentioned this, Jerry. Franchisors going forward, if this NLRB thing and all the fight and battle we have goes against us in the grain for both franchisors, franchising and franchising in general, do franchisors now become more corporate open locations versus franchise locations? What does those services look like? As Jerry alluded to, do you retract certain things that have been there expected of franchisees, especially multi-unit franchisees who are buying in their platform ownership different styles of brands? It's going to be a tough navigation if they succeed this.
Yep.
Mike, if I could jump in here, from a legal perspective, I think, Sam, like you said, 12 years ago, everybody saw it and the decisions, and they all backed away. And I had a lot of systems come to me and say, well, now I got to stop providing the training systems. I got to stop providing the support. And clearly that's not the answer. As franchisors, to be a good franchisor, like you said, right, your role is to be able to provide the support. And I think our job here, as veterans of franchising, is to figure out, okay, how can we continue to provide the support and yet not cross the line? Is certainly a lot blurrier today than it was a month ago, unfortunately. But I hate to, maybe I'm too much of an optimist, but I continue to think that there's got to be a way for franchisor to provide that support, and our job is to figure out how to do it. And maybe it's just a different way of communicating to franchisees. And education, I think, is a huge aspect of this. How do we educate not the people on this call maybe, but how do we educate all of our field support people? How do we educate our area representatives to understand this concept so that they can help us be able to provide the support and not step over the line? But I think Sam touched on a very important point, which is information. That's my biggest concern. Does retaining the information in itself cross that line out if, retaining the authority, to have that control? It's by virtue of the fact that you have information of the franchisees. Is that going to step over the line? And that's what we have to be able to provide some guidance on. And it may depend on what kind of information, how we keep the information, right? And how we store the information.
No,
Well, let me pitch in.
yeah.
I'm sorry. I would tag team what Sam and Amy both just said, but Amy touched on it. And, just think about what she mentioned about the complexity and what needs to go into trying to figure out how to navigate through this system. And frankly, we're probably going to learn the hard way about what doesn't work to navigate through the system, where something was put in place with a field person who interacted with an employee the wrong way. And then there's a lawsuit that goes against both sides of that. And God love Amy and the other attorneys out there fighting this battle, but I'm looking at it as a franchisee, and I'm sure franchisors are looking at this just the way Amy described what we've got to go through to figure out how to navigate that. That is going to be millions of attorney dollars and on an ongoing basis. And for those of you that think it's only franchisors that are going to carry that load, I hate to awaken you, but there's going to be a lot of franchisees, already have been franchisees. I can think of several franchisees in the 2015 to 2017 model that got pulled into it and had to spend tens of thousands of dollars to defend themselves against a joint employer situation. So I love the optimism Amy adds. I'll say my prayers tonight that it works out that way. But the fact is, I think it's going to be a long haul to get to that point.
Thanks, Jerry. And Amy, you talked about retaining information and all sorts of other franchisor practices. I mean, how are you advising clients to potentially take the business risk in this new environment of continuing these certain relationships and activities with the franchisees in order to protect their brand and still, navigate this new, very blurry, non-bright line?
I think the key is to go into the risk with your eyes wide open and take the risk that you absolutely must take in order to move the brand forward and to protect the brand. What I have learned is that with a lot of franchisors, we may retain in the franchise agreement the authority, right? Everyone has heard reserve the right. Well, use those words carefully. Do we really want to reserve the right in the franchise agreement to have control over these 20 things that, if I talk to my client over the last 20 years, have you ever exercised this control? And the answer is no. And I suspect the answer is no. When I ask clients that, inevitably, the answer is no to a lot of different issues. But the answer is a definitive yes with respect to certain issues, right? And that will differ from industry to industry. For Sam, food safety, clearly very important, right? You will do what you need to do to make sure that your customers are safe. And that food safety is going to be something that will impact, the brand if it goes wrong. For a different concept, it may be, equipment, right? It differs from brand to brand. And my recommendation is to make sure that when you look at your franchise agreement, when you look at your operations manual, to continue to retain the authority only where, it makes a huge difference.
That's right. And the franchisor has to take aggressive steps, right? Because as a franchisor, we have to survive.
Right.
We're the ones that have to survive to support the franchisees. And it gets more broader than what we just talked about, what Amy just mentioned. Think about technology integrations and platforming. I mean, you get into that hornet's nest, and this could be a 3-hour more Zoom. In the restaurant space, most all restaurants have enterprise systems. Well, those enterprise systems punch out data, and in those enterprise systems, they have employment scheduling. They have employment checking, clocking in and clocking out, as just a virtue of an option of the system. Does that mean now, because we chose that enterprise system, that we're joint employers if there's an issue? I mean, this it's really, really a big hornet's nest when you start looking at it, even on technology and all those integrations. What could the NLRB, if this sticks, which I hope it doesn't, if it sticks, and they have this broad authoritative control definition, you could leave the very traditional in the restaurant space best practice of keeping the store clean, safe food handling, keeping consumers safe, keeping it all the things you have to do in a restaurant physical plant. If it leaves that and then it goes to all the new normalities of post-pandemic, where everybody's layered in technology of all kind of angles in the restaurant space, as non-restaurant spaces have. Do all those technologies that are there to do good things, retract data for the franchisor to be able to keep the modeling going forward, give benchmarks and KPIs to franchisees to help them drive their bottom lines. Are those technologies now in the firing sites, on the cross sites that say of the NLRB? So it's a disappointing scenario we're dealing with.
Yeah. Thanks, Sam. So let's take some questions from the audience. We have several in here, and one of them is first one's very consistent with what you were just addressing, Sam. Maybe I'll pose this to Amy, but Sam and Jerry jump in. The question is, how do you see this joint employer rule affecting how franchisors and franchisees work with third-party vendors, like hiring software, enterprise software, and the like? Amy, comments from that?
Technology, like Sam says, is so important to every franchise system at this point, and it gives access. Franchisors have gotten access to a lot of information because of technology, and franchisors have been able to use that information to help franchisees get better bottom line, right? And that's all of our goal here. But I think the question is, can we use the technology and yet make certain changes to that technology so that we can still obtain the information that we need and still try to, I won't say it's impossible to always 100% protect the franchisor, right? But how do we minimize that risk? So the scenario that Sam was talking about, getting information about employees, right? Can we get information about how many hours each employee is working, so we can be able to advise the franchisee, you've got too much, your costs are too high because you've got too much overtime, right? But yet have technology be able to help us by creating a system that you could check the box from the franchisor's perspective to make sure that the franchisor at least is not getting the employee information, knowing when the employee clocked in, when the employee clocked out, but is still getting enough data to be able to help the franchisee. That's, from a technology perspective, that's what I'm hoping that will be the trend. We went from no information because we had no technology to all the information because we have great technology. And so now, how do we use that technology and still streamline somehow the information, I guess?
Great, thank you. Next question is on training. how could the joint employer rule impact training of franchise employees at corporate positions like outside sales reps for a franchise? Thoughts on impact on brands getting involved in training?
Well, from a restaurant perspective, I can tell you that that's one area, our brand, I think brands are going to have to, walk the gauntlet, because you have to train your franchisee and your franchise owner. You have to train, in our case, they're assigned agents, and then you go to help a location open in a restaurant space, and you send in 8 or 9 people there to get that location up and running. It's just not possible not to do that. You can't automate the training. It's got to be live training. It's got to be hands-on training. Those are going to be all battles from a legal perspective of what Amy's talked about. We're going to have to try to figure out language in the FDD, language in the FA, how we make that deliverable happen at the ground level. And all that costs money. I mean, you go to a technology platform and tell them, hey, I bought the platform, or I put it into use as best practice because it gave me all the data that I needed to be successful in creating more solid benchmarks and KPIs for my franchise owners. Oh, now I need you to dilute this, and this, so I don't have any NLRB action against me. That's just not a fair position for the franchisor to be in, or the franchisee to be in. And if you do cut that training module, you cut that training procedure and process because of this maybe becoming a fruition of guidance in our country, is the franchisee now put in a place that they're going to have a higher turnover ratio and drive their costs up and elongate their break-even points of what they purchase based on the FDD numbers and the things that they interviewed and looked at. So it's bad for both sides. And I'll yield to Jerry on the franchisee process of that.
Yeah, thanks, Sam. I've got a couple comments here. Number one, related to training, you brought it up. I think in 2015 to 2017, we saw a lot of franchisors draw back on some of the training they were doing that they felt was too near and dear to the franchisee, the employees of the franchisees. We've noticed a trend as to more and more of it going virtual. And to Sam's point, there are some things that can't be virtual, but we've got franchisors continuing to try to make those non-virtual things virtual, because I think it's an effort to not have their employees directly involved with training some of those things. This has only done a couple things. We've got worse training in the field, and it's cost franchisees a ton of extra cash that they were never planning on when they put their pro forma together to gain the training that they need for their staff, literally in any business out there. So the training side of it, I think, is huge. The relationship between field employees of franchisors and the franchisees and their employees is going to be skewed. I'll go back one question real quick and touch base on the technology thing. Our family is loyal. We're loyal beta testers for new POS systems, new technology that's coming down the pike. Every franchisor has got to have franchisees that do alpha and beta testing on anything new that comes out there. Bottom line is, in that case, franchisors' employees have to be talking to our employees on a regular basis, because that's where that training, that very in-depth training, problem solving with the new technology, all of those things come directly from employees of corporate. And I don't see how that can even happen under a joint employer situation. So I think there's a lot of things nobody's even thought about in this relationship that are going to come to light and be very negative moving forward if this actually gets into place.
Let's do one more. And Amy, this one start with you. How does the joint employer rule affect wage and hour claims and other employment lawsuits for franchisors? Is that going to change? Obviously, we have some wage and hour factors being considered, but this is under the collective bargaining law. How do you see that one?
Yeah, it's very similar, wage and hour, and how much guidance. I think actually this one, it's a little easier for franchisors to try to stay out of. Wage and hour laws, are, for the most part, collective bargaining perspective aside, more local, right? There's state regulations that govern wage and hour, and franchisors typically are not giving guidance to franchisees in each of the local jurisdictions. But from this perspective, I think franchisors will continue have to be careful how they relay the information, and to making sure that they may be providing information but not giving directives and guidance on the information. Now, what I usually tell franchisors is, this doesn't mean that you can't provide the information, because I still believe that providing information is not reserving the right to control or reserving that authority, right? So how do to the extent franchisors have information to be able to provide guidance to the franchisees, how do we do that and communicate that, and maybe, advise the franchisees of certain new rules have come in place, but to still say to the franchisee, make sure that you're looking into the local guidance and the laws in your jurisdiction, right? Unfortunately, the systems where they have smaller franchisees, not multi-unit franchisees, multi-unit franchisees, so Jerry, have more access to information, right? But I'm more worried about systems with the mom and pops. They only have each of one location, right? How do those people have enough money to go pay lawyers to get this information? And so it's going to be really important for franchisors to come up and maybe recommendations with respect to, there are more and more third parties out there that are providing wage and hour information to franchisees. And my hope is that some of those organizations maybe will work with the IFA to figure out how can they more effectively help their members to be able to provide that information.
Good questions, good answers. We'll get perhaps a final comment from our speakers in a second. I want to zoom to the next slide on a couple more points about the landscape that everyone needs to know on this issue. First of all, what are the moving pieces on this issue? How is IFA advocating for you? First of all, legislation. IFA was very pleased that dozens of members of Congress last week, November 9th, introduced a resolution that would repeal this new NLRB rule. So we will be pushing that, running a business coalition in Washington here and around the country to help ensure that that moves ahead and presents the administration with a real challenge to this rule. And also importantly, IFA is also leading a lawsuit. In the litigation bullet, you see also on November 9th, IFA filed a lawsuit in the Eastern District of Texas Federal Court challenging the NLRB rule. We were joined by 12 other business trade groups, and we're hopeful that that will ultimately be successful and block this rule. So with all the bad that's going on, there's a couple different avenues for fighting this rule, delaying it, and eventually defeating it that we are levers that we are pulling. And on the next slide, I want to give everybody an opportunity to weigh in a unique way here on this program, especially if you're a franchisee or a former franchisee. On the next slide, we're going to show you a QR code you can use to give a testimonial about your business, just like the one on your screen. Bill DePaula, as you see, is a New Orleans restaurant franchisee. And the U.S. Senate resolution to repeal the NLRB's rule here was introduced by one of the Louisiana senators. And that Louisiana senator, Bill Cassidy, whom we're very grateful to, included this quote from Bill DePaula, IFA member, in his press release about how important the franchise model is to him, how grateful he was for Senator Cassidy pushing back to help, as the quote concludes, to help ensure that he can remain an independent business owner. So now we're going to ask everybody on this call, and we'll be doing on the next slide, to scan this QR code, because you can quickly take a photo of this slide, and the QR code should pop up that takes you to a website where you can quickly give a very similar 3-sentence testimonial about what your franchise business means to you and how you are urging your members of Congress to eliminate this totally artificial and unnecessary rule that will be so cumbersome for the franchisor-franchisee relationship. So I hope everybody takes their phone. If you're a franchisee, if you're a franchisor, take your phone as well. Grab a hold of the website, send it to your franchisees in the days to come. They can fill out their story just the same, tell their how valuable franchising's been for them, what's at stake in this issue, as as Sam suggested, that long term, does the Dunkin' Donuts model go the way of Starbucks? Do franchisors continue to feel incentivized to sell licenses to third-party franchisees? Or as leases expire in the coming years, if this policy holds, what does that mean for the franchise model? So a great opportunity. We will capture these quotes. We will spread them around in some of our documents and advocacy in the days ahead, and it'll be a really, really important way that everyone can weigh in. So then on the next slide, we are, as we wrap, I do want to give, I'm very grateful to our expert speakers here. Jerry, Sam, and Amy, just wanted to go back to each of you, perhaps final comments. What's at stake in this issue? What's the importance of advocacy as we move forward? Jerry, I'll start with you.
Well, you stole some of my thunder, Mike, as usual. So I'll start this way. Amy had some great comments about, the large franchisees having access to more information and potentially more money to spend on attorneys and things like that. So my second point related to that is I think we all need to have great attorneys. If you don't already have them, you need to reach out and get one, because if this goes into place, I think attorneys are going to become our best friends. It's going to be an ongoing thing. I've already seen cases of this in the earlier rendition. I think advocacy is huge. If you haven't helped advocate before, I would suggest you get into it right now, because we're going to need a groundswell of information and opinions and insight into our businesses and our families going to Washington, D.C. And my last comment would be, I did not get into franchising to share the responsibility of my small business with corporate. I want to use their systems, and I want to take them to the next level and put them on steroids. I will never be able to do that if I'm sharing responsibility for those employees, because the employees are the face of our organization. Thanks for the opportunity, Mike.
Sam Ballas.
I can repeat everything everybody said, and I won't do that. I'll say dig into it's FDD season. Dig in with your attorneys, look at your language, be preemptive as a franchisor just in case. Educate your franchisees. If you're a franchisor and you haven't communicated with your franchisees, you need to communicate with your franchisees. And of course, what Jerry just alluded to, absolutely. If there's, even if you're afraid to, don't know how to, advocacy, especially at the franchisee level, that's what our politicians want to hear from, is our franchisees are out there. So reach out to the IFA if you're not understanding how to do that, or if you're afraid to do that, to all the forums, and we'll help you get your advocacy moving in the right gear. And lastly, hopefully we don't have to deal with this. I would say that make sure that your technology platforming is not giving you any type of a bullseye, so to speak, when you're doing your FDDs.
Thanks, Sam. I'll ask on your comment on advocacy, I'll ask our studio operator to put the QR code back on the screen one more time as we close, for people to scan that one more time. Amy Chang, how do you see the days ahead playing out? Final thoughts from you.
I think Sam stole my thunder using the word educate. I can't use that word enough times. I think that in order for us to get through this and to continue to promote franchising, franchisors need to educate everyone on their teams, how they communicate with franchisees, educate everyone from top to bottom about what this means, right? What the issue is, so everybody understands. And franchisees, I think, have an obligation to educate their employees. That's just as big of a topic that I don't feel like we talk about very much. Franchisees should be able to educate their employees about franchising and how they're the franchisor, and about joint employment, and that no, the franchisor is not your employer, I'm your employer. So if we educate on both of those fronts, my hope is that together we will be able to educate the public. And that, in connection with the advocacy, is how we're going to hopefully move forward and get through this.
Such great insights. Thank you, Amy Chang, Sam Ballas, Jerry Akers, for being a part of this and sharing all your expertise. We're out of time, but thank you everyone for being a part of this. Thank you for clicking on the screen and sharing your franchise testimonial and being a big part of our Franchise Action Network advocacy against this rulemaking. We hope this was helpful, everybody. Again, the joint employer rule becomes effective on December 26th. So review your documents, review your relationships, and we need to, until other news breaks, we need to point to that December 26th effective date. So again, thank you everyone for joining us. We hope you have a great Thanksgiving, and we look forward to seeing you all soon.